Officer Dade, would you open my courtroom, please?
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning. Good morning, Counsel.
Good morning, Your Honor. How are you?
I'm good. Happy Friday.
Happy Friday. It's a beautiful day.
Yes, it is. Mr. Kremper,
Good morning, Your Honor.
let's get started on your file. This is file 21240-982. Inygar Yoga of Detroit versus Michigan First Credit Union. The date and time for a motion to set aside dismissal filed on behalf of the plaintiff. Your respective appearances.
Good morning, Your Honor. This is Jessica Spratzoff on behalf of the Iyengar Yoga Collective. My P number is P70218.
Mr. Kremper,
Good morning, Your Honor. Michael Crump on behalf of the defendant, Michigan First Credit Union, P76494.
plaintiff, your motion.
Your Honor, we'd ask that the court set aside the dismissal order that was entered without notice. I apologize for not appearing for the hearing. I was surprised that I did.
I didn't understand. What was entered without notice?
The order of dismissal. There was not an
Why was the
opportunity.
order of dismissal entered?
I'm sorry.
Why was the order of dismissal entered?
My understanding, and I'm not sure because I didn't get a notice from the court, is that it was entered from, I got a notice that the order had been entered.
Yes.
My objection to it is that I was not given an opportunity to appear before my client's claim was dismissed.
Well, let me just take a look at the record here, counsel, because my recollection appears to be a little different than yours.
Okay.
My recollection was the matter was set for pretrial at our pretrial on April 11th, 2022, a date and time agreed to by both parties, and that you failed to appear. Is that factually accurate?
Your Honor, I mistakenly did not appear. It
That's
was a
not my
mistake.
question. My question was it factually accurate that we had an agreed upon date and time for pretrial? You got written notice of that pretrial and you did not appear. Are all those things factually accurate?
And yes, that is accurate, Your Honor. And what I'm saying is I'm asking that the court not penalize my client for my mistake. And I would also remind the court that we have complied with everything that the court has asked, including getting the case evaluation scheduled, which opposing counsel knew about, knew that we were actively participating in this case. And I have appeared for every other hearing. This was an error. I haven't missed a hearing, in my career. And I would ask the court to not penalize my client with this dismissal. I would also argue that it would be inefficient to start this case over from the beginning. We're well within the statute of limitations time.
So
And
if we're well within the statute of limitations time, there would be no prejudice to your client to restart, then would there?
If Mr. Krempa wants to go through discovery again and, do this case in front of another judge,
It wouldn't be in front of another judge. It would be assigned here because I had the previous case. You're digging a
would
hole.
Your Honor like to go through this again? I'm confused.
What I'm saying is this, your argument that it's well within the statute of limitations argues that there is no prejudice to your client for me refusing to set aside the dismissal.
I
The
disagree.
question about talking about going to another judge is factually incorrect because you would have to disclose on your complaint that there had been a prior litigation and the case would be assigned to me. So I'm not understanding either of those arguments.
So my question, my proposal is, if we go back to the beginning, my client will have to spend time responding to discovery again. So will Mr. Krumpa's client. Should we start over? Is that your preference? I guess I'm confused about that.
Counsel, this is your motion.
My position is we shouldn't start over. We should go to the case evaluation as ordered, and the case should be reinstated.
Mr. Kremple.
Thank you, Your Honor. Not to belabor the point, Your Honor, but MCR 2.612, which provides the authority to provide relief from an order, has very specific grounds on which a motion to grant relief must be based. The factual circumstances here don't fit any of those circumstances, and in particular, MCR 2.612 C1A, under which plaintiff filed their motion, doesn't cover failure to calendar a hearing date. So I don't believe there's proper grounds to grant the plaintiff's motion. And in addition, if plaintiff were to refile, which they may or may not do, then if it's an issue of discovery, that was something that would obviously be able to be discussed and dealt with in the subsequent case.
Well, let's see. In the district court, how do we have discovery?
Only by order of the court, Your Honor.
Or stipulation of the parties?
Right.
Anything else you want to tell me, ma'am?
Your Honor, I'm just surprised, frankly, that it seems to be an inefficient process when we are moving in the direction that the court wanted, and opposing counsel knew that the case evaluation was being scheduled, and I was working with him to get that scheduled. Yes, it's scheduled. It's scheduled for July 11th.
All right.
And to start this over seems to be a very, inefficient use of your time and Mr. Crumpa's. But if that's
taxpayers pay for my time. I'm saying whether I have 100 cases or one.
Well, I mean, as a taxpayer,
another month, I don't get anything extra. So what can I say? Taxpayers are already paying for my time. Let me make a suggestion. I think that there are arguments that have been made, some of them cut in favor of the plaintiff. However, many of the arguments raised by the plaintiff cut in favor of the defendant. You concede the lack of prejudice. The argument
I did not concede the lack of prejudice, Your Honor.
I'm sorry. Well, what is your prejudice? I'm having started again.
The prejudice is my client has been out of this money for a number of months. We are getting towards a resolution at case evaluation.
Are you guaranteeing you're going to accept the case evaluation?
Your Honor,
you
are sending us to case evaluation to mediate this case in the hopes of a resolution. If not, my client would like to try the case. And if we start from the beginning, my client will be prejudiced because it will not reach, a decision point at either case evaluation or at trial for a number more months.
How is that prejudice?
They have been deprived of their $4,000.
Are they not, assuming for purposes of our discussion?
I'm sorry, Your Honor?
Assuming for purposes of our discussion, your client were to be successful at trial, is there such a thing as interest on judgments?
Your Honor, I'm talking about the present value of money. So they have been without this money because it was removed from their account by a fraudster.
All right.
Defendant is refusing to repay them the entire amount. And so they are operating without that $4,000, which is a large sum of money to their organization. And they are having to do other things because that money was not returned. That is continuing prejudice to my client.
All right, court's prepared to rule on this one. I am going to grant the motion to set aside the dismissal under MCR 2.612 C, mistake, inadvertence, or excusable neglect. As a condition preceding to that, counsel for plaintiff will pay attorney fees in the amount of $250 to the defendant within 14 days of today. Now, you told me that you have a case evaluation scheduled?
Scheduled for July 11th, Your Honor.
July 11th? Okay, let's get you a date then. After July 11th.
And I believe the parties have, 14 days to accept or reject?
Where's my calendar? Oh, so let's go to July 11th. July 29th. Does that work for everybody?
Yeah, my only question, Your Honor, is does that account for the 14 days the parties have to accept or reject?
As a practical matter, counsel, you're going to know that anyway. 11 and 14 is how much?
Okay, I'm sorry. What is the day that you're proposing?
11 and 14 is how much? 25.
Yep, that's my question.
29th, would that be after 14 days?
Yes, that is. July 29th is good for me. Thank you.
Mr. Kremper?
July 29th is fine with us, Your Honor. Thank you very
July
much.
29th at 10 o'clock, we'll have a pretrial. In the meantime, I'll send out an order granting the motion to set aside the dismissal conditioned upon payment of attorney fees to the defendant of $250. That amount to be paid within 14 days of today. Is there anything else we can accomplish today?
No, thank you, Your Honor.
Anything
No,
for
Your
you?
Honor.
All right. Thank you both for coming in. Let's be safe. We're off the record.
Thank you, Your Honor.
Uh-oh.
Ms.
Uh-oh.
Williams, good morning.
I apologize, Your Honor. I could see the message. I was just, something was wrong with my computer where I couldn't get the volume to work properly. I apologize, Your Honor.
No problem. What case do you have today?
Today I am here on, this is,
Progressive Marathon versus Fisher?
yes, Ricky Fisher.
Okay, I don't have Mr. Fisher as of yet, so I'll put you back in the waiting room.
Okay, thank you, Your Honor.
Good morning.
Good morning, Your Honor.
We are going to call 21170-663 Louis Bartholomew, versus MJ Realty Service PLC. By a notice dated May 25, 2022, this matter is set for hearing today at 10 o'clock on the plaintiff's motion seeking satisfaction of judgment. Mr. Bartholomew, I don't have the other side as of yet, but I got a response from them today. When did you get a copy of that response?
A response from the defendant?
Yes.
I have not gotten a response from them as to the motion for summary judgment, but
What summary judgment for satisfaction of judgment?
oh, for satisfaction, no, I did not receive that response as of
Okay.
yet.
It came to me today, and
Okay.
looking at the cover letter, it looks as if it was overnighted on June the 8th. So you would probably not have gotten it. So
Okay.
I'm going to give you an opportunity. To me, it's fair that you have a chance to read and at least be prepared to respond to it.
Mhm.
I'm going to adjourn this matter for a week. So we'll hear your case on, it's going to be June 17th, at 10 o'clock. I'll send out a notice today, noting that the response on behalf of the defendant was filed too late here.
Okay, thank you, Your Honor. One other clarification, my counsel also, when he received the notice that it was today at 10 a.m., he had a conflict and he sent a few days ago to one of your aides, Ms. Davis, asking also for an adjournment. So that works out well for us.
Okay, because I haven't had an appearance. But anyway, it's not fair that you don't have an opportunity to respond. So I'll
Yes.
send out that adjournment notice to you today. It'll be June 17th at 10 o'clock.
Okay, thank you very much, Your Honor.
Have your attorney, if he's going to get involved, he's got to file the appearance and appear again at that time, okay?
Okay, thank you very much.
Thank you. Yes, sir.
All right,
Be
bye-bye.
safe out there.
Thank you, you as well.
Thank you. We are on the record. Let's get Ms. Williams in here. We are on the record calling file number 17127-956, Progressive Marathon versus Ricky Fisher. By notice dated May 24th, this matter is scheduled for hearing today, June 10th at 10 o'clock on the defendant's motion for satisfaction of judgment. It is currently after 10:30, your appearance.
Good morning, Your Honor. Tiffany Williams on behalf of plaintiff, P number 74809 for the record.
All right, Ms. Williams, I have a problem here. I have a response with a cover letter dated June 8th from you. It came to my desk today. Under the court rule, there's no less than 3 days entitled for the hearing. Mr. Fisher has not appeared. Did you serve him a copy of this?
We did serve him with a copy of this. We sent it overnight as well. It reached our office late, and so that's why we
I'm
returned
sorry.
it late.
I don't understand what reached your office late.
So it was mailed. It looks like, well, I don't have his motion at all, but I do have the notice. I do have the notice from the court. And so we got the notice from the court, I believe, on Monday. Yeah, it had to be Monday of this week because I drafted this on Wednesday and I drafted it on Tuesday. We overnighted it Wednesday, and that's why the court had it on Thursday. So that's kind of how we ended up here. But I don't have his motion. I responded to the motion, but I don't know what the motion said.
Yeah, we mailed this out to you on May 24th.
Right. No,
That would
I
be-
saw that.
That's more than 2 weeks from today's hearing date.
Yeah, I understand, Your Honor, that's what the proof of service states. But as far as when we received it, it was in Monday's mail.
Well, what I'm going to do is I'm just going to adjourn it for a week. And that way he will have had time to see the pleading as well and be at least positioned to move forward. May 24th is more than 2 weeks. That was 2 weeks from Tuesday. And so I can't explain that, but I can't proceed with the matter at this point in time because I haven't had a chance to review your pleadings. So we'll send it or adjourn it May. I'm sorry, not May. It'll be June 17th at 10 o'clock.
Your Honor, can I also request, I have not received his motion itself. I received the notice of the hearing. I don't know what he's alleging in his motion.
I'll ask my clerk when she sends yours out to send you a copy of his pleading as well.
Thank you, Your Honor.
All right, and that's going to be June 17th at 10 o'clock. Thank you, Counsel.
Your Honor, and I hate to ask. So if it gets sent out today, I'm concerned that we may not receive it by the 17th. Our experience, the mail has been really slow. I'm not sure what's happening. I don't know. Do we have the capacity to email it by any chance? Or
I'm not going to do that. You want to have your runner come down? I may have a copy made and I'll leave it with my court clerk, or we'll put it in the mail today.
Okay. Thank you, Your Honor.
Thank you, Counsel.